To understand the FCC's recent rules, we have to understand some of the history behind them. We can begin with the Communications Act of 1934. The Communications Act created the FCC as a 5-member commission. The statute insulated that commission from direct presidential oversight by limiting the president's power to remove commissioners based on disagreements over policy. The Communications Act gave the FCC substantial authority to regulate interstate and foreign wire and radio communications. One tool the statute provided the FCC appears in what's known as Title II of the Communications Act. Title II was designed to permit federal regulation of telephone service, in part to address the problem of monopoly. Title II permitted the FCC to regulate providers of telephone service as common carriers. Under Title II, the FCC could regulate providers' prices and terms of service. One of the critical requirements of common carrier regulation is that a carrier must provide service on a non-discriminatory basis. And indeed, a common carrier must treat a competitor just as it treats a customer. The requirement that the telecommunications service provider grant non-discriminatory access to its services fostered the development of dial-up internet access, since internet service providers could demand access to the telecommunications infrastructure on the same terms as the provider offered other services. But Title II common carrier regulation only applies to those who provide a telecommunications service. As the internet developed, one critical question was whether a provider of internet access, such as a cable company offering a cable modem service, should be classified as a telecommunications provider under Title II. If so, the FCC would have the authority to demand that the provider offer access to its infrastructure on the same terms as it offered its own services. In 2002, the FCC classified cable modem service as an information service rather than a telecommunications service. That classification was challenged in court. Ultimately, the Supreme Court of the United States held that the Communications Act was sufficiently ambiguous that the FCC, as an expert agency, ought to receive deference in its interpretation of the statute. So based on the FCC's classification of cable modem service as an information service, cable modem service was not subject to the common carrier regulations under the Communications Act. In 2005, the FCC expanded this conclusion to cover wireline broadband service more generally. So DSL, as well as cable modem services, were freed from the strictures of Title II of the Communications Act. In fact, the classification of these providers as information services precluded the imposition of any common carriage requirements on them. When the FCC issued its 2005 order on the classification of wireline broadband services, it also issued a significant policy statement on net neutrality, embracing certain principles that Commissioner Michael Powell had advanced in his speech in 2004. The FCC outlined 4 principles in its 2005 policy statement. 1. To encourage broadband deployment and preserve and promote the open and interconnected nature of the public internet, consumers are entitled to access the lawful internet content of their choice. 2. Consumers are entitled to run applications and use services of their choice, subject to the needs of law enforcement. 3. Consumers are entitled to connect their choice of legal devices that do not harm the network. And 4. Consumers are entitled to competition among network providers, application and service providers, and content providers. Although the FCC did not adopt actual rules, it committed to incorporating these principles into its ongoing policymaking activities. But it stated that the principles adopted were subject to a carrier's reasonable network management. Did the FCC have the legal authority to announce and enforce the 2005 principles? That question would ultimately be resolved